Well, welcome back to the Law&Crime Network. My name is Bob Bianchi. I'll be with you at 3 o'clock, and we have an awesome set of trials and some great guests here today, as always. And happy Columbus Day for all of you who celebrate or are in favor of that holiday. I am for one. Okay, there you go. It's as simple as that, and the die is cast as you will. Kirk Burkhalter is one of my regular guests here at the Law&Crime Network. I always love it when I read the guest trial rundown and I know that he is going to be on the show. He is in studio, a professor at New York Law, 20 years with the NYPD at a very, very high level as a detective, has done long-term investigations, organized crime, enterprises, and terrorism. He's published, he's a TV legal analyst, and you know what? I'm adding something to your resume, Professor. I just thought of it because it's an absolute truism. An all-around good guy.
Welcome I appreciate it. Appreciate it.
Okay, so what did you make with regard to to that? And I'm being told just as a quick interruption that we believe. Let me just make sure I get this here because this is a breaking development. That there is going to be testimony from the defendant in the case that we're covering today. So that will be interesting because when a defendant takes a stand, obviously there's going to be a situation where they can either make or break the case. Very dangerous. Real quick on that thought. I mean, when a defendant taking a stand, it's going to be very, very, very important.
Absolutely. And here, well, all defendants, most of the time, they're not attorneys, so they don't know in particular what might advance their cause or what might hinder their cause. And in particular, in this case, this defendant has shown bizarre behavior at the least.
Yeah, Markel Lloyd, previous hearings, has gone off in front of the judge, cursing, and you see a picture of him right there. And with a skilled prosecutor, I used to like to think that I was one with a defendant, you can poke and prod a person into an emotional frenzy on the stand.
Absolutely, and I would not be surprised if that might be a tactic here. After all, he's on trial for a violent murder, and what better way to show the jury that he is liable for the crime to have him create one of these outbursts and so forth. It certainly would not help his cause at all.
Right. And going back to the verdict with Garcia, did you find it interesting that the jury was unable to come to a conclusion with regard to Magbanua, but was with regard to Garcia when there was so much evidence of the connection of her as being a middle person in this?
It's very, very interesting, and I would suspect that perhaps one or two people, meaning jurors, hung up on this. So there's a direct connection, or there was a direct connection with the shooters. And but she was, a lot of hands-off, a lot of circumstantial evidence, and some folks just want to see that absolute direct connection, meaning money transferred or fingerprints and so forth. And what we had was a lot of conversations between her and the brother-in-law, and I think that might have played into this also, the fact that the brother-in-law wasn't on trial.
Yeah, I can tell you as a prosecutor, there was a lot last week of the jurors asking questions about the law. And whenever the jurors were coming out and they were asking about the law, I started to get that creepy feeling as a homicide prosecutor because the law is very complex. It's not understandable. The judges kind of read it out and spit it out. But this jury was asking a lot of questions about what is a principal and who isn't a principal. I think those questions had to be right geared towards Magbanua.
I would think so, especially when you have someone that is an accessory before the fact or after the fact, or it's a conspiracy. Jurors start asking questions about accessorial liability. That can't be necessarily a positive thing. That means they have some questions as to whether this person's actually culpable.
Yeah, and interestingly enough, we're talking about in the Markel Lloyd case that he's expected to take the stand in that case. Well, Garcia did not take the stand in the Markel murder case, but Magbanua did. And so this may be one of those instances. How you look at it, folks, when you are a prosecutor, anything other than a guilty verdict is considered in our minds a loss. That means there has to be a decision to retry the case. There's more transcripts. There's more opportunity for the defense to be able to cross-examine witnesses. Memories fade. And now the defense knows exactly where the prosecutor is going with their case, which they didn't know before. So it's never a good thing. So Magbanua taking the stand, essentially, I believed, helped herself. Let's take a look. Okay, well, there you go. The defendant on the stand. The jury could not come to a unanimous decision with regard to guilt. Prosecutors now have to make a difficult decision. So in addition to the professor that's here with us in studio, outside of studio, we have another guest, Leslie Richard Chambers from Baton Rouge, Louisiana, a great part of the country. She is a former prosecutor, and I know you wanted me to keep it sweet and short when we were talking before we got on there, but I cannot help but to mention, because one of our chatters in the chat room who often, goes back and forth with us. So like our second jury said they love the way I introduce guests. So if you want me to just say former prosecutor, that's what I do, because I know you're doing some important work with the government. Otherwise, well, guess we'll keep that a secret until you want people to know. But I note on your Twitter, which is a public profile, so therefore I am allowed to state it without your consent. You identify yourself as a mom, a wife, a sister, a mentor, a trial lawyer, and policy advisor. Fair enough?
Fair enough. Got me.
Welcome to the show.
Thank you.
Okay. So let me ask you, starting off, Leslie, Mgbonwo taking the stand. Now, we've seen some disastrous cases that we've covered here at the Law and Crime Network where they have literally fallen apart on the witness stand, but obviously a jury couldn't come back with a conclusion with her. I know this is really difficult to ask somebody in your position or our position, but do you think that she helped herself, or had she not taken the stand, do you think it would have been better for the prosecution?
Well, I think that she took that stand to solicit sympathy from that jury, and I believe that she was able to do that. And the defense's argument was that she had nothing to do with this, and I believe that surprisingly she was successful in getting the jury to side with them, that that she had absolutely no connection with this murder, helping to arrange it, helping to orchestrate it. So surprisingly, she took that slim chance of taking the stand, and she was obviously successful.
All right, well, Professor, nobody salivates more in a trial than when a prosecutor like myself, who doesn't have an opportunity to force a defendant to the witness stand because they have a right to remain silent, and you really don't know what it is that they're going to pop up with, when that defense lawyer says, Your Honor, my client wants to take this stand, you are like, okay, man, it is showtime. But you got to deliver the goods too. So with all of that evidence that was out there, and again, to alert our audience, if you may not have seen it, she had direct contacts with the family, the estranged family of the ex-husband, and she had dated one of the brothers, and she had also dated Mr. Garcia, and there's all these text messages. There's a chart of it. It's kind of like a circular thing, if you will, but all these text messages in such close proximity, and all these phone calls that were wiretapped. Cops did a great job. I don't get it. Thoughts?
Well, I will tell you something that struck me right away. We heard these recordings of the conversations where she was cursing like a sailor and so forth, and then we see her on the stand. And nothing could be further from how her demeanor in the conversations. And I speculate here, because certainly I haven't spoken to any of the jurors, when a person has to make a choice between two extremes, they're going to choose one or the other, not something in the middle. So either the jury believed that this was the real defendant, the person on the stand with this calm demeanor, or the one who is using all the curse words and so forth in the tapes. And then perhaps her taking the stand negated some of the influence of the recordings from the conversations.
Interesting. We used to say when they would take the stand, they had their communion outfits on.
Yes.
And they were acting all prim and proper, despite what you don't listen to your lying ears, as it were, when you're listening to the actual tapes of the person in real time. Anyway, listen, it was a success for the defense in the case, because I always say this to you guys. At the Law and Crime Network, to a defense attorney, it's only getting to 1. That's what you'd like to get to 12, but if you could just get to 1 and hang that jury, that is considered a success. And that mistrial verdict strikes a sword through the prosecutor's heart. Speaking of mistrial verdicts, in this case, or mistrial rulings, when they can't come to a unanimous decision, let's take a look as it represented, or as it related to Mgbonwo. All right, there you go. Leslie, let me ask you, as a former prosecutor, explain to our audience what this means when you're listening to this as a prosecutor. I could tell you when I was a baby prosecutor handling homicide cases, thank God it never happened to me, but when there would be a hung jury or a not guilty, you were immediately called down to the front office, we used to call it, and advising your command staff as to what occurred. So what conversation is occurring with them who invested so much time in Mgbonwo's case?
Well, I can tell you from experience that when you have a jury verdict such as this, your heart drops, your stomach is turning, and you are replaying everything that you should have done that you didn't do, and you're replaying everything that you were probably told to do that you decided, not to do. And I think that the prosecution, I'm sure, experienced those same emotions, and now they've got to go back to the drawing board and now go back to the principal's office to really nail down what those points are, what they missed. And, I don't think that it was a good conversation between these prosecutors and the hierarchy in the prosecutor's office.
Yep, got to make a big decision with regard to retrial, when to retry, how to retry, and maybe, guys, I don't know, maybe see if Garcia is willing to talk now that he is convicted and in the sentencing phase for capital murder. I don't know. I certainly would be pulling all strings possible in order to resolve this case. Guys, we got so much here at the Law and Crime Network, all these multiple trials, multiple unbelievable guests. Happy Columbus Day. That's my Columbus Day present. We got to do some business here at the Law and Crime Network. We'll be right back.